Zoom. You may much prefer in person. I'm not going to argue with you. But all things considered, the amount that we've done in the past year to get this working, to make this actually feasible, is frankly stunning. I give credit to the school, to the dean, to my colleagues, but just the amount of work to make this all happen with very little prep is astonishing. So I hope you all just can sort of pause in the moment and reflect on what it is that we're doing here. We'll be back in person in the fall. I'm pretty confident about that. I think it'll happen if you get your shots in time. But this is a semester which you're going to remember. Your first year of law school is done in Zoom, and I'm sure you hate it. You're all miserable, but you'll be telling your grandkids about this one day that, I lived through the pandemic. I survived, and I had law school on Zoom, right? But it'll be a story if nothing else. All right. Almost there, guys. Almost done. All right. Questions before we begin? No? And I do hope all of you come visit in the fall when we're actually allowed to be in person. You come say hi to me. I will appreciate it. All right. Let's start with the poll question. Just review our material from last class. Here is the chat, the link in the chat. And let's try question number 1. Okay, question number 1. And question number 1 begins, L leases Blackacre to T. T then assigns his interest in Blackacre to S. S fails to pay the rent. And it's judgment proof. L can sue T for the rent that S failed to pay. True or false? Okay, who's next?
Me.
Okay, Sarah. What's your answer, Sarah?
I said it's false.
Okay, why?
Because it was an assignment, not a sublease.
What's the difference between an assignment and a sublease?
An assignment is, I don't have the exact definitions. I put my computer on top of my car and then drove away. My computer smashed. So
Oh no, that's awful.
It's a really bad timing for this to happen, but okay, so I think the assignment is like when you give your whole thing, and a sublease is when you give less than half or something. I don't remember the exact.
All right, do you have your notes backed up in a cloud somewhere?
I don't have any of my outlines or my notes or anything.
Oh God. All right, well.
So I'm working on it though. I'm gonna figure it out.
Let me. I'm not talking to Sarah now. This is a lot of you. You need to use backups, guys. It's not an excuse. I've had some of you tell me that you had your computers crash the day of illegal writing memos due. Backups are not expensive. Use Google Drive, Dropbox, anything. I like Google Drive because it syncs automatically. I don't have to think about it. Everything just syncs automatically to the cloud. I don't have to do anything. I've had computers crash, and I just go buy a new one. I'm back in business the next day. There's no downtime. It's completely seamless. Within minutes, I have my entire everything backed up. When I was in law school, we had thumb drives, which just doesn't really exist anymore. But you need to have backups. And this is not just for law school. You have an obligation to clients, right? If you're working on a client's case and your computer crashes or your computer's stolen or your computer flies off your windshield, right? It's not an excuse that you can't make a court deadline. So I don't need to pick on Sarah. I'm sorry, but let her lesson be a lesson for you all to use effective backups. Even if you just email files to yourself every now and then, that's a sort of an old school backup format. But really, use Google Drive, use OneNote, use Dropbox, use something that's automatic. You have to think about it. If you have to actually do something, it's something you're likely to forget. Oh God, I've never done that, but I once put my my little thing when they get when you have the gas can, a little gas can lid. I put that on my windshield. I drove away. That flew away. That's the closest I've ever done to what happened to Sarah, where I lost my gas can lid in the car. But oh man, that sucks. Once I was in the Costco parking lot, the one in Richmond, and a guy had a flat screen TV sticking out the back of his trunk, and we went over a bump, and it fell out of his trunk and just smashed right in the parking lot. He didn't even make it home with the TV. It was one of these huge, the 60 inches, right? The huge ones. It just smashed. And you could just hear it crack right on the floor. Oh, man. Bad. All right. But Sarah's correct. The answer here is B. After the entire wind-up, I'm sorry. I didn't mean to pick on you, but you're the second or third student this week who told me about a computer crash. So I have to usually have a virtual crash. This is a physical crash of a computer. An assignment is when you give your entire interest in a lease to someone else. A sublease is where you give part of your interest. With an assignment, the tenant, T, is completely out of the picture. The tenant is no longer in any sort of relationship with the landlord. All rent is due to the sublessee. Now, it's for this reason that landlords don't like assignments. They much prefer subleases because there's more people to sue. But if you actually have a sublease that's consented to, then the tenant is out of the picture. Questions? No? Okay, let's begin. In our last class, we discussed cases where the tenant breached the lease. For example, the tenant held over. I'm sorry, we discussed cases where the landlord breached the lease. For example, there was a holdover tenant. The landlord didn't make the premise available. Today, we're doing the opposite, where the tenant is at fault. Right? The tenant's at fault. The tenant breaches a lease. Or the tenant holds over. Or the tenant fails to pay rent. Everything we're talking about today is modern. Right? Almost all the jurisdictions today have adopted modern rules. They've abandoned common law. And this is not usual. Right? Usually we say that the common law rules are followed in most states. But for property, landlord-tenant law has become very much a modern enterprise. And we'll see today two cases that sort of move away from the common law rule. Okay? Questions so far? Okay. All right, so the first topic is about the tenant who defaults. Now, when I see the word default, most of you think of a default font, right? In Microsoft Word, Times New Roman, whatever, right? Default font. But the word default is really a synonym for breach, to violate. Right? To default on a lease means you don't follow the terms of the lease. To default on a mortgage means you don't pay the mortgage. To default on a loan means you don't pay the loan, right? So the word default just means breach. So if you ever see default, just think of breach. What happens when a tenant defaults on a lease? Can the landlord obtain back rent? Can the landlord evict through the courts? Or can the landlord engage in what might be called self-help? Miranda, are you here?
I'm here.
Miranda, at common law, what remedy was available to a landlord if there was a breach of a lease?
They can use self-help to retake possession of the lease from the tenant.
Good. Help us out here. What exactly is self-help? What does that phrase mean?
It's like when you take the law into your hands as opposed to going through the courts.
Okay, how? How would a person take law into their own hands? What does that actually mean?
Like they can change the locks out without the tenant knowing, or do something that would inhibit their possession of the property.
So Miranda, what happens if the tenant is in the unit? Do you change the locks with them inside? You lock them in?
No, I usually do it when they aren't there.
Wait till they're not there. And one more question for you. If you change the locks on someone and use self-help, what happens to all their stuff inside their apartment?
I guess they can't get to it anymore.
What can you throw it out?
I guess you can sell it,
What do you use that money for?
rent, or improving the property, or
Yeah, very good. All right. So thanks, Miranda. So at common law, we have this remedy called self-help. Right? At the most basic level, I think Miranda said well, self-help is when you take the matter into your own hands. You take the law into your own hands. The most common type of self-help is just changing the locks. And you change the locks. What happens if the person's stuff inside? At common law, you could sell it and use that rent money to pay off the debts owed by rent. Now, Alexandria here. Alexandra? Nope. Jeanette, I'm sorry, Rachel, you here? Rachel? Nope. Jeanette?
I'm here.
Okay. Jeanette, so at common law, at least in Minnesota, there were 2 requirements to use self-help. What were those 2 requirements?
It had to be, well, the landlord had to be legally entitled to the possession
Okay.
of the place, and then the means that he would use to re-enter would have to be peaceable.
Okay.
So if he did those 2 things, he would be good.
All right, so it's the first one. When would a landlord be legally entitled to retake the premise?
I would assume if the tenant defaults, if he wouldn't pay rent, and that's in the contract, I mean, obviously. And
Okay, we'll get to this. We'll get to the second factor in a minute. We'll do the peaceful one in a minute. Jeanette, is it always clear whether there's a default?
no, I don't think so.
Why not?
Well, if we go back to the case, I mean, it wasn't clear whether the tenant had actually abandoned or surrendered the property. So sometimes they might do something like post that notice that she posted where, the restaurant was closed because of renovations or whatever they were going to do. And so you might construe that as, okay, she left, so I can go ahead and take possession again. Or you might say, well, she's doing repairs, so she's going to come back, she's not surrendering anything.
So, Jeanette, let me ask you this question, right? Why might it be problematic? Why might it be problematic if the landlord takes it into his own hands to decide if there's a breach?
Because then the tenant can sue the landlord.
No, you're right. Of course, the tenant can sue the landlord. But why is it problematic when the landlord decides for himself whether there's a breach? Why might that be not an ideal way of resolving a dispute?
I believe the court said it was because it might be a breach of the peace, so they might fight with each other.
You're right. But that goes to the second one, right? Hold on. Sebastian, you here? Sebastian, why might it be problematic when the landlord gets to decide for himself if there's been a breach or not?
I mean, I was going to say what Jeanette just said, where it could lead to violence between the parties. Again, and locking stuff in and then selling it unreasonably.
Well, that's fine. My question is different. Do people often agree? Do parties always agree if there's a breach?
Almost never.
Almost never, right? So if the landlord says it's a breach, what might the truth be?
It could be. It could also not be.
Could there be a misunderstanding?
It could.
Could maybe the landlord be full of it and just making crap up?
That is also true.
Right. Have a landlord ever acted dishonestly in the history of the world?
I know mine has.
Yeah, usually people say that at this point in the class, right? Has your landlord ever done Spider-Man and hang off your awning?
No, but they did steal a bunch of artwork and wine from my parents.
Oh no! Oh, don't. That's not good. All right. Thanks, Sebastian. All right. So here's a very simple point. I think Sebastian said it well. There will always be a dispute about whether there's a breach. right? Maybe not always, but actually almost always. The landlord will say, breach, 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 right?
Say no breach.
What was that, Jeanette?
Oh, I'm sorry. I said the tenant would say no breach.
Yeah, exactly. Finish my sentence. Thank you. Thank you. So the landlord says breach, and the tenant says no breach, right? And usually the way we resolve these disputes is through the courts, right? And the judge says, well, I'm going to hear the evidence, and I'll decide that either the tenant's right or the landlord's right. But with self-help, there's no neutral arbiter, right? There's no neutral third party to assess the argument. It's the landlord takes the law into himself and says, aha, I think there's a breach, and that's good enough, so let me go put a padlock on the door. Let me go lock them up. Everyone get that? So Sydney, you here? Sydney?
Yes, I am.
So then there's the second factor, right? That I think Jeanette said a minute ago. I can't remember who it was. Maybe it was Miranda. I've lost count. Right? Peaceable, right? That the reentry must be peaceable. Let me ask you, Sydney, is there any peaceful way of evicting someone? I mean, let's just be candid here.
I would say no.
Yeah, I mean, can you think of any nice way of kicking someone out of their apartment?
No.
Will anyone ever be say, you know what, Sydney, you're such a nice landlord. I'm just going to pick up and just go. Is that going to happen?
No.
No. What's going to happen?
I would imagine there's violence in a lot of cases, or at least arguing.
So what's like the most, or let me say it differently. What's the least confrontational way of evicting a tenant with self-help? The least confrontational way.
I thought what the landlord did by bringing the locksmith and the sheriff with him was, it encouraged peacefulness at least.
Yeah. I mean, like, I know the court beats up on the landlord, but I mean, could he have done it any better?
I can't think of anything that he could have done differently.
Right. I mean, other than the Spider-Man business, right? But yeah, thanks, Sydney. Very good. So if self-help is possible, coming to the building with a locksmith and a sheriff when the tenant's not there, in my view, is like the least worst option, right? It's not ideal, right? No one wants to get evicted. And perhaps the tenant was, the landlord was mistaken. There was not a breach, right? We don't know that for sure. But the way that the landlord went about this, all things considered, is kind of reasonable. Dare I say it? Right? It's not like, what he did on Friday the 13th, we'll get to that in a minute, was just weird, right? That's some shady stuff, right? But he came back the next Monday and he sort of did what the law allowed him to do, I think. All right, we'll see. All right, thank you, Sydney. Luis, no, he emailed, he's not here. Lance, are you here?
Yes, I'm here.
Okay, Lance. Lance, you want to give us the facts then in Berg v. Wiley?
I cannot. I'm sorry.
Susan?
Yes, sir. Berg versus v. Wiley. That's the one where the brothers started the original lease and to have a restaurant, right?
Well, he had a pool hall initially.
The pool hall, yeah. And he had conditions in the lease. It was a 5-year term, and he couldn't make any changes to the building without permission. And if he did, it was breach, and the landlord could take back the property.
Mm-hmm. Good.
Okay. And then he changed the rent. Like, he left maybe a year or less than a year, and his sister took over to open a family restaurant.
Mm-hmm.
Right.
Good.
And she kind of remodeled without permission, and then had a bunch of when the landlord went to check on everything, he issued a requirement for her to make certain changes to the restaurant to bring them up to code and make it so that it was a better restaurant. And then the health department came in and also issued almost the exact same list to her. And so she had 2 weeks to make these changes, but she actually kept the restaurant open for 2 weeks. And then at the end of the 2 weeks, started the remodel.
Did she? Did she start the
Yeah.
remodels? How do you know that?
Started. I had friends and they were there and said they were doing the remodel. And they saw the landlord hanging from the awning spying on them.
Okay, I think you're choosing very good. What a weird case, right? I mean, like, I would love a picture of this restaurant. And like, I just want to see like how high up is this awning that this guy is like hanging. And I'm thinking, is he hanging like, like this, like with his hands in the awning? Or is like he repelling like Batman with his legs on the top of the awning, kind of looking upside down, right? That's which one is it? Which one do you have in your mind? I think he's upside down, right? He's like, like this. Weird. So we have Friday the 13th, right? Weird day. But before this, a lot of things happen. So on June 13th, the health department comes by and they say there's a list of changes that have to be made, and they gave her 2 weeks. Or actually about a month. They gave her about a month. And a couple weeks later, the attorney for Wiley writes and says, you have to make these changes. Grayson, you here?
Yep.
Grayson, can a landlord demand that the tenant make these changes in the span of 2 weeks? Is that something landlords can do?
I don't think so, no.
Why not?
Well, I would think first of all because they kind of sign the lease to the property, and at that point it becomes theirs. So they get to decide what they do with the land.
Did this lease impose any obligations upon the tenant?
Yeah, conditions were given that you couldn't make modifications to the property unless they were cleared or you were given permission by the landlord.
And then was there another one about operating your property consistent with the law?
Right. Since this was the property was meant to be a restaurant, the landlord wanted to make sure that the restaurant was following health code violations. So
could a landlord demand the tenant bring the place up to code? Is that something a landlord can do consistent with this lease? You want to say yes, but you don't want to say yes.
Yeah, I want to say because he has a right to re-enter, but I don't think that he can downright make them do it.
Well, look, the lease says, I'm reading right from the lease, it says, operate the restaurant in a lawful and prudent manner. That's what it says right there in the lease. And if you don't follow the conditions of the lease, you can re-enter. Is violating health codes operating in a lawful manner? You're fighting it, I can tell. You want to say yes, but you don't want to say yes. I get it.
I'm gonna say that that's a lawful that's a violation of the law.
I mean that's an easy one, right? You're running a restaurant, you have health code violation. That's an easy one. So Grayson, let me ask the follow-up question. Why can't the landlord simply say, if you don't do what the health department said by a certain deadline, I'm going to kick you out?
Because that seems to be a modified condition. Like the condition wasn't I can kick you out.
But it says if you violate the terms of the lease, I can retake possession. Why is it not exactly what the lease says? If she makes the repairs the health department asked for, then he has no claim, right? But if she's operating in violation of the health code, then it's not lawful, and then he can retake possession.
Right.
You're fighting it so hard.
Yeah, what's the question exactly?
Why can't he retake possession if she's operating in an unlawful fashion? There's health code violations. Why can't he retake possession?
I'm not sure.
Man, you're fighting it. Quinny, I think you're in the classroom. Yeah, let me put you on mute. Go ahead. Why can't he retake possession? If she's operating in violation of health code, why can't he retake possession?
And I mean, I guess I would still believe. Sure, is she actually breaching the lease, I guess, then?
I'm sorry, it's a little hard to hear. Say it again, please.
Sorry. The lease, okay, wait, so the lease says that
The lease says you have to operate in a lawful fashion.
Right.
Health code says you're not operating in lawful fashion. You're violating health code. Why can't he retake possession on that basis alone? Forget the renovations.
Not sure.
It's hard to take inside the landlord, isn't it? No one wants to ever take inside the landlord. I love this case.
He should be able to.
Yes, just say it. It's okay. The landlord's right every day. It's okay for the landlord to be correct. The law isn't always in favor of the little guy, right? Or the little woman in this case, right? All right, thanks, Quinny, right? The law here, I think, look, if she's in violation of the health code, right, the landlord can say, I can retake possession because she's in violation of the health code. And I think the timing here is important. The health code said make your changes by, what is it, by July, was it July 13th, right? That's when the health code said, July 13th. And by the way, health code violations are matters of public record. It's not like it's secret. They put that sign up on your wall. It's, they list different health code violations. So it would be very easy for the landlord to come by and say, oh crap, right? My tenant has health code violations. There's 8 of them. They're significant. There's a very good chance that if she doesn't make these violations, the state will shut her down. She's not going to pay my rent, and I'm going to be out of a tenant. So why don't I just cut my losses short and say, okay, if you don't make these changes by the day the government requested, I'm going to evict you. Right? Rhea? Oh, no, Rhea emailed me. Ray, you here, Ray? Okay, one second. Let me go to the classroom. Ray, let me ask you a question. What if instead of, he did a Spider-Man bit, right? Let's say he just went to court and moved to evict her as of July 13th. Could he have done that?
Yeah, I think the court would have really preferred that counsel.
Yeah, and do you think the court would have ruled in favor of the landlord in that case?
Certainly.
I think so. Right. This is a clear breach in my mind, right? This is an easy breach. So, but Ray, did he go to court on July 13th, on Friday the 13th?
No, he man.
Yeah, okay. Walk us through the shady conduct. This is it's almost comical, but just walk us through what happened on the 13th. A lot of stuff happened.
Yeah, so they were like, it was her and some friends. They were moving some stuff around, and he was.
They weren't just moving stuff around. What were they doing? Let's just be candid here.
Was it? They were moving part of the floor or part of the wall?
Well, they were taking paneling off the wall. So maybe they were doing this part of renovations, but they may also be just stealing stuff that wasn't bolted down. They
Right.
just that's Susan smiling. Yeah. They were just taking whatever wasn't bolted out. All right, go ahead, Ray. So they were taking paneling off the wall, and then what does the landlord do?
He's basically like banging on the walls, throwing a window, like I don't really know how he's doing it, but he's like basically demanding like they let him in.
Okay, very good. Okay, thanks so much, Ray. So I just want you to envision what's going on, right? On the 13th, he comes there, tries to change the lock. And she's like, what the hell? I'm still here. And she says, fine, I'm not going to change the lock now. Later that evening, Kathleen Berg is sitting there with her friends in the restaurant, and apparently they're ripping siding off the wall. Now, that might be part of the renovations, or they might just be stealing whatever's not bolted down. We don't know. And somehow, and again, I'm trying to visualize this, the landlord is hanging off the awning. Awnings aren't that strong. How do they hold a person's weight? I don't know, right? Whatever. I always sort of laugh when I read this case every year. So he's hanging off the awning, and they see her, and this actually causes her the intentional infliction of emotional distress, which doesn't really go anywhere, but you can imagine it scares the crap out of her, right? So who is this guy hanging on my awning? Okay, next what happens, he starts banging on the door. It says, let me in, let me in. And she's like, not by the hair of my chinny chin chin. No, wrong. Sorry. I have little kids. Sorry. It plagues my thought process, right? She doesn't let him in. Then she calls the cops, or she calls the sheriff, right? And it's like, this guy's threatening me. And then he calls the police, and she's like, this is my apartment. She's in breach. I need self-help. So the sheriff and the police broker a truce. They mediate a truce. And the truce is just keep the status quo. Don't change anything till Monday. Don't evict her. Don't change the locks. Don't make any damage to the property. Just let everything sit. and they agreed to the truce. At that point, Linda, you here?
Yes, I'm here.
Okay, Linda. So at that point, Mr. Wiley goes to his lawyer, and his lawyer gives him some advice. What advice does the lawyer give to Wiley?
So, yeah, the lawyer gave bad advice and said that he needs to take possession of the premises and lock the tenant out
Why was that bad advice?
because the court's not happy that their power was taken away.
Oh, wow. What a smart comment. What do you mean by that?
Well, I mean, as this court goes on to say that they're going to adhere to the modern rule where it is much more peaceable and effective to go to the courts. And I believe Minnesota has a system where if you go and ask the courts for help, there's the rapid process and you can get a decision in 3 to 10 days. And it's, better all around.
But I want to, you said something very sharp before. I'll just go back. You said the courts don't like to be crowded out or have their job taken away from them. How'd you put it? You put it in a very smart way.
I think I just said the courts don't like the power taken, their
Yeah.
power taken away.
The courts don't like self-help because that means they have a job, right? It's their business. All right, very good, Linda. I like the way you put that. All right. So the lawyer gave what Linda says is bad advice. I'm not sure it's bad advice, right? Let's just break this down for a bit, right? Alexander, you here?
Yes, sir.
Okay, you're in the classroom. That's right. So there are these two factors that justify self-help in Minnesota, right? Remind us what those two factors are.
The factors are if they have legal they're legally entitled to possession.
Good.
If there's like a holdover, they can kick them out. And then the second one, if the landlord has means of relief. If the means of relief is reasonable.
Okay, good. So let's do one at a time, Alexander. So the first one, did Mr. Wiley have the legal right to retake possession at that juncture with the health code violations that were not fixed?
Yes.
I think so. This is easy. It's also not clear she had written permission to do the renovations, right? I think absolutely the first factor satisfied. Okay, again, so now second one, Alexander. The lawyer says, look, go there first thing the Monday morning when no one's there with a locksmith and with a sheriff and quietly change the locks. In your mind, if you're giving advice, Alexander, is that peaceful?
I think it's, you described it as the least bad way to do it, right?
Yeah.
You're bringing the police, you're bringing the locksmith, there's going to be a record of it, the policeman can testify if things happen.
So was this bad? I mean, Linda said it was bad advice. It turned out to be bad advice. She was absolutely right. The court said bad advice, right? But at the time, would this lawyer be on the hook for malpractice? In other words, did he give advice that's contrary to law, Alexander?
No, because this court changed the common law. So he's giving
There you go. We got the same business with California last week. Remember that one last week where the Pestana case where they randomly changed the common law?
Right.
When you're in New Jersey, when you're in California, good luck being an attorney.
This one's Minnesota, right?
Yeah, I'm sorry. The other case is New Jersey, but yeah, same thing, right? You're right. New Jersey was our second case. I apologize. But if you're in one of these states that's reversing the common law, good luck being a lawyer. Because you give your advice to your client based on what the law is, on Monday, and on Tuesday the law is something else. So again, it turned out to be poor advice. Linda, you're not wrong. It turned out to be very bad advice. But at the time it was given, I think the advice was sound, right? He had the legal right to do it, number one. And number two, this is like the least confrontational way. You have the police there, you have the sheriff, you have a locksmith with you, right? This is not like you're banging in the middle of the night. If he hadn't done that, I mean, imagine if he had just waited till Monday morning and just locked her out without hanging on her awning. I think he might have actually won the case. And just one other note, right? She filed this lawsuit July, was it 27th? This is a person who obviously had access to a lawyer already. Couldn't you have just gotten her act together and fixed up the restaurant, in 2 weeks rather than having to deal with all this other crap? So I don't know if she actually intended to make the repairs. I think Susan said the scare quotes or something a few minutes ago. Yeah, there she is. Right. I don't know. I am skeptical. I generally don't. Sorry, this is not me, but I don't trust people usually either way. I don't trust the landlord or the tenant. I think most people lie. So I suspect she was trying just to peace out and ghost. You ever know there's a 59 diner? It's right by 59 and near where Shepherd is, near Trader Joe's. It randomly closed for repairs 7 years ago. It hasn't reopened since. It's, you know where the halal guys is? You're 59 and Shepherd. Yeah, there's a diner. You'll see it. It's just like it's vacant. It's still there. It's a vacant building. And there was a sign that was put up like in 2015 that said closed for repairs, and it's still closed for repairs. So it's a very common technique in the restaurant business that when you are shutting down, you say, "Oh, closed for repairs," right? And you fire everyone, lay off all of your staff, and then you move on. I don't know. Does anyone ever work in a restaurant? Does this actually ever happen? They actually make repairs and come back a few months later? Anyone? Anyone want to defend Miss Berg, Alyssa?
Well, I've worked in a restaurant for years, but that's never happened.
No. When they say closed for renovations, they're gone.
They've never been closed for renovations while I was there.
Okay.
Well, except for when there was the Harvey, the flooding.
That's true. That's a fair point. Garrett, go ahead.
Only time I've seen it was when COVID happened. A lot of restaurants, like the one I worked in at the time, actually did repairs, and a lot of others did in the town as well. But that's it. Besides that, they don't actually do that.
Yeah, they usually don't reopen. Okay. So Mrs. Berg sues the landlord for wrongful eviction. Forget the IIED. Don't care about that one. Okay. Okay, back to the top of the alphabet. Who do I have? A. Nicholas, you here?
Yes, sir.
So, Nicholas, walk me through the court's opinion, please.
Okay, so the trial court says that Wiley did lock her out and that it was wrongful. Are you talking about the trial court, or are you talking about the appellate court?
I want you walking through the Supreme Court, the state Supreme Court's opinion.
Just a second. So the court essentially said that the modern rule, including the summary procedures, are the exclusive remedy by which a landlord may remove a tenant claiming possession.
One more time. Let's try this again. At common law, Minnesota, was self-help ever permissible?
No.
Exactly right. Dana, you here?
Yeah.
Dana, walk me through the court's opinion, please.
Okay. So basically, well, self-help was a remedy before in Minnesota, but this court decides to abandon that common law rule for allowing for self-help.
Well, we'll get right. We'll get to the abandonment in a minute. But under the common law, why was the action here unreasonable? Why was the eviction here unreasonable?
They say it was unreasonable, number one, because it wasn't accomplished in a peaceful manner.
Okay.
They said that by changing the locks while she was absent wasn't peaceful. And the second reason I think that they say is that a self-help reentry against a tenant, I think under the modern doctrine, they should resort to a judicial process to remedy that.
Yeah, Dana, why am I putting aside whether there's violence? We'll put that aside for a minute. Why is it risky if Mr. Wiley, the landlord, decides for himself that there's a breach? Why is that problematic?
Well, I guess because it's kind of one-sided. Even though if you have a lease or these term agreements, if he's just deciding for himself, you're kind of just on that borderline of if that's lawful or not. And so you kind of need the court to adjudicate that matter for it to be proper.
Mm-hmm. Good. Thanks, Dana. So there's a couple issues here to think about, right? One, is there actually a breach, right? Is a tenant actually in default? Now, I think she was, right? But usually there's disagreement. In almost every single breach case you'll ever have, the parties disagree, right? 100%. If the parties agree, they won't go to court, they'll settle, right? There's always things, well, I didn't follow the health code, but I was going to do it later. This 2-week deadline's arbitrary. I got an extension from the state. There's a million things the tenant can say about why they were not in breach. right? What does lawful and prudent manner mean? Does lawful mean that there was a health code violation, or that maybe there was an enforcement action taken? Were you fined, right? Usually the government gives you a warning, then gives you a fine, then they actually enforce it later, right? What does lawful action mean? What does prudent mean, right? There are lots of defenses that Mrs. Berg could raise to challenge the lease. But when you have self-help, the landlord's a judge, jury, and the executioner. He decides for himself what the law is. He decides whether the condition has been violated, and he can take the matter into his own hands by removing the locks and changing the locks. Right? Judge, jury, and executioner. And the courts don't like that. The courts like having their own process. Also, the state of Minnesota creates summary procedures. Nazreen, what are these summary procedures? Nazreen? Elizabeth? What are summary procedures?
Summary procedures for eviction. So at common law, they prefer the self-help. The new modern summary procedures is intended to be a quick and effective means by which landlord can recover the possession after termination of tenancy.
In Connecticut, not Connecticut, in Minnesota, how long do the summary procedures usually take?
Typically 2 months, I believe.
No, not in this case.
Sorry, I think I have.
You're reading from the notes after the case. You're not reading from the case.
I'm not sure.
Okay, the answer is 3 to 10 days. Okay, thank you. Right, so the state allows summary procedures which allow quick evictions. A common law ejection was a very lengthy action. It could take months. And a common law, it made sense to have self-help because why would you go to the courts and take months where you can kick the person out in a few minutes? But now the courts have allowed summary procedures, which is basically 2 weeks, 10 days, 3 weeks, right? A fairly short period. And because these quick turnaround times are permissible, there's less of a concern about delay. And there's less of a need for self-help. Okay? So in this case, you can take it out in about 2 weeks, 10 days maybe. The court also says that this is not peaceable. Again, I don't know how he could have done it less confrontationally, right? This seems to be the least worst way of doing it, if you can think of it that way. But the court says even this is too much. The court says the only reason there wasn't violence was because the woman wasn't there. Well, yeah, no kidding. That's why you did it, right? You deliberately do it when the other person's not there to avoid violence. Garrett, go ahead.
Does due process kind of factor into that policy decision as well either? It's kind of the landlord just unilaterally being get out and you don't have a chance to really be heard?
Do you know what due process is?
I mean, in context, we haven't taken con law yet.
I know you haven't. I got to admit, this is the most insane arguments in the entire book. The due process clause says the government cannot deprive you of your property without due process of law, some sort of procedure, right? This is not governmental action. This is a private landlord taking action. So I know this in the book. It's this maybe lobbying for con law in the spring. This is just an insane argument. I'm sorry. It's
heard about that.
Yeah, I would not pay any attention to it. I mean, this is going to sound awful, but it's really bad when property people do con law and when con law people do property, and I kind of do both. I guess I'm bad at both. But it's people sort of stay in their lanes. This is just an insane argument. I'm sorry. But thank you for asking. Yeah, I mean, there are lots of problems with landlord-tenant law, but the due process clause is not one of them. All right. So the court says even under the common law, Mr. Wiley engaged unreasonably. It's for the court to decide, and you should be using these summary proceedings. Okay? Any questions so far? Yeah, I really wish they would take out that note on due process because you haven't studied due process. It makes no sense. It's just what the hell is due process, right? The due process of law is the process you're due. It's some sort of basic procedure, some basic law that you're entitled to. Anyway, yo, Dallas, go ahead. Oh, you're in the classroom. Let me put you off mute.
I think so, yeah. So, I kind of think that, him showing up with the cops and like with the locksmith to remove the locks was good as well. Like, probably the most peaceful way he could have done it. But do you think that, the events leading up to, like, him being weird and creepy and hanging off the awning and like banging on the back door,
Yeah.
and just doing all that, like, is that probably, had he avoided doing that, the court would have found differently?
I think so.
Okay.
Had he simply gone Monday morning at 7 a.m. and put the locks, I think you have lost. It was his shady behavior of hanging off the awning and banging the door like a crazy person. I think he lost his case. Right. And again, Mrs. Berg managed to sue like 2 weeks later, so she had access to a lawyer. She seems somewhat sophisticated. This seems that they could have worked this out without going to the courts, but often a landlord and tenant have relations that are strained. And you'll find this when you're representing clients. People, how do I put this? People don't act rationally when there's a dispute. They become convinced that they're right and the other side is evil, right? And you're smiling, but it's true, right? And you start behaving in a fashion that's not rational. So I think there's a lot of irrational behavior going on in this case. Yes, Alyssa, go ahead.
So on the exam, we'll be applying both rules to common law.
I would tell you which jurisdiction you're in so you can apply either one.
Okay, cool.
We'll get to the modern. Let's do the modern rule. So Andrew, the court here goes ahead and adopts the modern rule. What's the modern rule in this context? Andrew, you here?
Yeah, I'm here. Sorry. So the modern rule is that
is self-help ever permissible?
No, self-help is not permissible. The default is going through proceedings. The court.
Never ever permissible under any circumstance. Never ever ever ever. Never
ever sounds pretty
that's
never. So there's always I'm sure there's always exceptions, but I believe the court says the only lawful means so I mean I'm just quoting from the case. They say the only lawful means for to dispossess of the tenant who has not abandoned nor voluntarily surrendered, but who claims possession adversely to the landlord's claim of a breach of a written lease is to resort to the judicial process. So if I'm interpreting from the case, I would say, never ever. Your self-help is never available.
I think that's right. Never ever 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 means never. The court says if you want to evict someone, you can't use self-help. You can't go and change the locks. You're required to go use the judicial process, which is, again, 2 weeks. It's not very lengthy, right? And this is actually the majority rule in most states. In almost every state, not all states, but almost every state, self-help is not permissible. And even where it's permissible, it's not advisable because the tenant can sue the landlord for wrongful eviction, and there might be treble damages, which are not easy to pay. I'll just give a little anecdote. I had an uncle who lived in New York who was quite elderly, and for many years he had an aide living with him who cooked his meals and helped clean and stuff. And then he died, and the aide wouldn't leave. She just would not leave. And she had no lease. She was just living there for years as basically an aide. And my uncle, the uncle's son, who was still living, called me and said, "Can we just change the locks in her when she's not there?" I'm like, no, don't change the locks. I'm actually thinking of this case. I'm like, do not change the locks, whatever you do. And my advice to them was to just pay her to leave. Because in New York, it takes forever to evict someone, especially if there's no lease. It's very complicated. So I think they just paid her to leave and she left, and that was it. But yeah, don't go off changing locks, even if you're allowed to under the law, because you're going to be on the hook for potential damages for locking her out. Okay. Questions on this case? And again, most states have followed the modern rule now. Texas does have the modern rule. Any questions? All right. The idea of these Sommer proceedings is really a 20th century idea. It's in the last 100 years that courts have made it very easy to evict someone. In Texas, the process takes about 3 weeks, give or take. About 3 weeks. Let me just walk you through the steps. The first step to evict someone in Texas is to give notice to vacate. And the notice serves an important purpose because it might give the chance to the tenant to cure it, right? To pay the back rent, to make whatever repairs are necessary. The tenant can do whatever is needed to stay in the apartment. Right? Very often the notice, like, oh man, I didn't realize there was a problem. I didn't realize you were serious. Okay, let me take care of it now. Right? In the Berg case, did the first letter the attorney sent constitute notice? Not really. It just said, if you don't do this, I reserve the right to enter and retake. That's not enough. The notice must be, I am moving to evict you. Not like maybe I have the option, I'm doing it. All right. 3 days after notice is given, you have to get the sheriff to serve a citation, right? Which is an official warning saying, okay, you now have to go to court, right? There's a hearing coming up on a certain date, and you have to go to court. And this might take 8 to 10 days. And then after this 8 to 10 days, you have a hearing. Now, the hearing, at least in Texas, is before a justice of the peace, a JP. They need not be lawyers. They often are. In fact, one of my current students in my First Amendment class is the JP, which is kind of cool. He had his Zoom background as justice of the peace, thing. People are like, oh, wow, look at that, but it wasn't his fault. This is where he was. The hearing is pretty quick. It's usually like, is there a lease? Yes. Did you breach it? Yes. Did you fail to pay your rent? Yes. Okay, you're evicted. Right? I mean, there's not much more to it. These aren't complex cases, which is why you have these sort of summary proceedings. These are not disputes of fact. Now, there might be defenses. For example, what if the landlord failed to provide heat or air conditioning and the tenant withheld rent to offset that, right? Or what if repairs had to be made and the tenant made the repairs himself and didn't pay rent? He used the money to make the repairs. So there might be some defenses, but usually it's, did you pay the rent? No. Do you have the money to pay the rent now? No. Okay, then what are you going to do? You're going to evict the person. At that point, there's 5 days to file an appeal, which is always possible. But again, those appeals are not very fruitful because they don't have the money, right? If you're getting evicted from an apartment, you probably don't have the money for a lawyer to file an appeal. That's just the general way things work. Then finally, the last stage is the constable, which is kind of like a sheriff, has to post a 24-hour vacate notice in the door. And you've seen these, maybe you haven't, but there's a huge sign that's saying notice to vacate, right? And they have 24 hours to get out. And at that point, the sheriff or the constable come and change the locks. So that's the process. It takes about 23 days from start to finish. It's pretty quick. Yes, Lacey, go ahead.
Sorry, I was trying to write down. You said the second step is it 3 days after the notice to vacate from the.
You have to get a citation served.
A citation, that's the word.
Yeah,
Thank you.
and it can take 8 to 10 days to get the sheriff to do that. Okay. So again, in Texas, it could take up to 3 weeks. Yes, Grayson, go ahead.
Is that going to be testable? Like, should we know that for the final?
Well, stop asking that question. Really, guys, you're law students. At this point, stop asking that question. The answer is yes. If I spend 5 minutes talking about it, it's on the exam. It's just it's an obnoxious question. I mean, you're now in your second semester. Just assume it is. If it's not, you know something that's useful for your life. All right. I'm not wasting my time or just speaking to the wind. I'm doing this for a reason. All right. Texas is a fairly quick process. In DC, for example, the book says over 100 days. New York, it could be up to 3 to 6 months. And you have to have 30 days notice. And by the way, if the process takes 6 months, you're not getting paid for that rent, right? Once you serve notice for eviction, there's no chance you're getting that money. It's not going to happen. So the actual process of eviction means the rent will go uncollected for at least 6 months, and you can't put the unit to anyone else. The book says Massachusetts for 2 years. My goodness, that's an insane amount of time. And that's just a lot. I mean, if you're the tenant who gets to live rent free for 2 years, like, yay, isn't that awesome? But what that invariably does is it raises the rent for everyone else in the building. And it creates a lot of problems for real estate markets because people can't get in and out of buildings. So you don't want to be a landlord with a 2-year deadbeat tenant. That's just not going to work. The other option is you make it much harder to become a tenant. You have credit checks. You have various higher security deposits. So there are ways of getting around that. Let's look at.
Well, I just read an article recently that made me think of this. Did you hear about there's a case in California where this couple bought a home from this guy, and then it was like right before the pandemic, and they went to the house to like move in. Well, it was like during when the pandemic was starting, and then they went to the house to move in after they bought it, and then like he just wouldn't leave.
Oh no, the holdover tenant, the prior tenant?
Yeah, he wouldn't leave. And then right after that, like they went to the court to get like the proper, like to get them to kick him out. And then right before they issued like the order for him to leave, they California issued the no evictions thing so that you couldn't evict anybody. And so then the guy ended up staying in the house for like 15 months. Even though the couple already bought it.
Yeah. Welcome to California. I mean, look, let me try to make your comment make a little more sense. In landlord-tenant law, it's very easy to favor the landlord, and it's very easy to favor the tenant, but you can't favor both, right? Depending which side you pick, you have a very different world. If you favor the tenant, it's like, oh, this is wonderful, right? You get to stay in this house for 15 months during the pandemic, right? Versus someone else bought this apartment and he can't get in, right? So it's hard to favor everyone. Someone's always going to be getting the advantage, whoever stays there paying rent free. There is one downside, though, and I think this is in the reading. If you are actually evicted through summary proceedings, you have a credit score that says you were evicted, which will make it really tough to get a lease in the future, right? It's going to be very tough. The book actually suggests that one of the benefits of self-help is it creates no paper trail, right? When you get your ass thrown in the, I'm sorry, that was mean. When you get when you get locked out, I should say, there's no record and it doesn't burn your credit. I shouldn't have said that. That was impolitic. I'm sorry. I shouldn't curse. I have a 2-year-old who's trying to repeat every curse I say, so I have to be very careful about not cursing. Trust me, it's F-bombs. Just I don't know where she gets it from. It's from me, obviously, and she's the other people, but it's problematic. So I'll try not to curse. All right. Any questions on the first case or on the summary proceedings? No? All right, let's do the next case. This will be for David. I think David B.
I'm here.
Okay, David. What were the facts in our second case, Sommer versus Kreidel from New Jersey?
Yeah, so the defendant, Kridel, signed a 2-year lease with Sommer and paid for the first month's rent and the security deposit. Mm-hmm. But then he wrote a letter to the landlord saying that his engagement has been broken off. And as a result, he'd no longer have money to pay the rent. And after that, the landlord received interest in the apartment, I guess, and he denied them being able to rent it. And then he subsequently waited for about a year, I believe, until he brought suit to reclaim lost rent, lost profit from the defendant.
All right, thanks, David. So look, this is a tragic case. Law student, engaged, pre-married. His future in-law has promised to pay his rent, but then the engagement breaks apart. This is like the opposite of the Graham case from Colorado, where the flight attendant wife puts husband through grad school. Here, she cut her losses short. I mean, this is going to sound mean, but who really wants to be married to a law student? Sorry. It's true, right? It's not. It's true. I'm looking at all those people wincing, but it's true. It's not a pleasant. Look, you guys are living the life, right? It's not pleasant. You work your butts off. You miss no parties, but you miss birthdays. You miss celebrations. You're studying all weekend. Thanksgiving break is studying for finals, right? You know the drill. So look, she cut her losses short, and then the tenant's like, "Yeah, I don't even have the money to do this, so just let me out, please. I don't even have the keys. I can't give them back to you. You can keep whatever I gave you the first and last month rent. Just show mercy and show grace and let me have the lease." Okay, Alyssa, I think you're next. Alyssa, let me ask you a question, please. Why do you think the landlord didn't let him out? Why the landlord just let the apartment sit there empty for like a couple of years and then finally he rented it out? Why do you think he did this?
I don't know much about the place, but it could be a couple reasons. I mean, maybe it wasn't that great of a place, so he might have had a little bit of trouble finding another tenant. Maybe the market went down, so the rent would have been lower.
But we know someone else was interested. He didn't rent it out.
Yeah, that's true.
So why would a landlord choose to let the apartment go vacant? In other words, if you get a tenant, it's a sure thing. You're getting rent every month. Versus if you're trying to sue this poor law student with no money, you might get it back in a couple of years, right? Why would you deliberately choose to keep it vacant, hoping to get the back rent, rather than just trying to find a tenant?
Well, two reasons that come to mind is one, there's a contract, so legally he would have a remedy if he wanted there to be one. So in that sense, a guaranteed.
Oh no, but what is it really guaranteed that you have a lawsuit just defaulted? No. Is there really actually any guarantee?
The second reason I was thinking was that maybe he was just lazy and like he didn't want to have to deal with an extra tenant, and it's just easier to get money for. And you never know what the tenant's going to do to the place, or what kind of complaints you're going to have to deal with. So maybe it's just easier to just deal with it.
Listen, let me ask you a question differently, right? Let's say you're a lawyer in New Jersey, right? And Sommer comes to you and says, I have this kid, signed a 2-year lease, never even showed up. Is it okay if I just keep it empty and we'll sue him later for the rent? You're the lawyer. What do you say? Under the law at the time.
Oh, under the law at the time.
What do you tell him? You're the lawyer in New Jersey.
I believe it was that they had a duty to mitigate the damages.
Was that the common law rule?
Ooh,
what did the trial court hold here?
Well, the trial court found in favor of Kridel.
And what did the appellate court do?
Well, they reversed.
Was there a duty to mitigate in New Jersey at the time?
Apparently not.
No, that's right. Okay, thanks, Alyssa. So look, this is the question I always ask you because I think it's the fairest question, right? You're an attorney in New Jersey and you read the common law, and the common law says there's no duty to mitigate. Your client comes and says, hey, so can I just let this apartment sit empty for 2 years? You say, well, it's probably a stupid thing to do, but yeah, sure, you can do that. Right? Again, clients don't always do it smart. Your job as an attorney is to tell them, well, that might be a dumb idea, but there's nothing illegal about it, right? Your client's allowed to make a dumb decision, just make sure it doesn't break the law. So you tell them, yeah, I mean, stupid idea, but there's no duty to pay. No duty to mitigate. And I apologize. You hear that loud sound. There's a landscaping outside, always Monday morning. Well, we're in New Jersey. And you know what New Jersey does to the common law? They reverse it. So, Javon, what does the court do here? Read the classroom? I'm sorry. There you go.
Yeah, I'm in the.
I got you. Okay. What does the court do here?
So the court ended up reversing the appellate court's decision
Why?
because they said that the landlord has a duty to mitigate damages by making a reasonable effort to re-let the premises and seeking to recover from a default tenant.
Okay, so I want to just make sure I heard what you said. The landlord has a duty to mitigate and try to relet the apartment. What exactly does he have to do to relet it? I mean, how much work does he have to do to find a new tenant?
Well, they said like reasonable effort.
Yeah, do we know exactly what that means?
I mean, I guess like in this like particular instance, like he told he had someone who was willing to lease the place, and he told him no. So I mean, that doesn't sound reasonable.
Yeah.
But in this instance, he should.
Yeah, this is probably an easier case because there was actually a tenant who came around and he said, no, I don't want it. So maybe Alyssa's right. Maybe he just didn't want to have the headache of a tenant. He said, no, it's a sure thing. I get to sue this lawsuit in a couple of years to be a lawyer and make a lot of money. I guess the rules never get involved with a lawsuit with a lot of free time in his hands because, and then someone in my last class said, who are these lawsuits with free time in their hands? These people don't exist, right? You guys are nodding. I know. I mean, he spent all these thousands of dollars on this case over the years for what, a couple $1,000s in damage? But again, it's personal. And this is maybe why you should never represent yourself, because you have a fool for a client, as the saying goes. Anyway, thanks, Siobhan. That's very good. So the court here adopts this duty to mitigate, which is not the common law rule, but it's the modern rule. And it's really the rule that's been adopted in the majority of states. Texas and 40-something states have this rule. So in just about every state you'll find will be a duty to mitigate. But what's unusual here is how the duty to mitigate works. Odalis, you here? I think I saw you earlier.
Yeah.
Here, right in the classroom. So Odalis, let me ask this question, please. Right? Usually when you allege someone breached a duty, right, who has the burden to show the duty was breached?
So,
right, I sue you for violating a duty of care. Who has the burden to show that you violated this duty of care?
you do.
I do, the plaintiff, right? But in this case, who has the duty to show whether this duty is violated? Oh, so who has the burden to show if this duty was violated?
The landlord.
The landlord. How's that work? What does the landlord have to show?
They have to show that they could have avoided the damages that accrued from the.
Yeah.
Sorry, what?
Yeah, that's right. Go ahead, keep going.
Oh, okay. Yeah, so they have to show, they being the defendant, has to show that the damages could have been avoided if the tenant would have just paid the rent. But I think what Javon was saying, that they have the defendant also has to show that they, I'm looking directly at, well, I'm not going to tell you the page because you're probably not looking at the book, but they have to show that they either personally or through like some sort of agent offered or showed the apartment or made some tenants or advertised it in local newspapers.
Yeah, very good. Excellent. Thank you, Dallas. Excellent. Right. So the landlord has a duty to show due diligence, right? That he took specific steps to relet the apartment. And if, for example, there might be advertising it, hiring a listing service, right? These are not free things, right? These actually have costs involved. But the court imposes this burden on the landlord. And I suppose it makes some sense, right? How could the tenant possibly know which people came by to look at the apartment, right? How can the tenant possibly know whether advertisements were placed and, what kind of listing services they used? The person in the best position to know these facts would be the landlord. And therefore, the court puts a burden on the landlord. In this case, the landlord just sat there, waited more than a year, and let the damages accrue. The landlord could have avoided the damages, but he didn't. Therefore, the tenant is off the hook for rent. Right? It's a crazy holding if you think about it. I know the facts here are egregious, but he signed a 2-year lease and he didn't pay anything except for the first and last month rent. All he was on the hook for was his deposit. That's it. After all this, the law student prevailed. Questions? All right, so I guess the lesson is mitigate your damages always. All right, any questions, guys? Yes, Alyssa, go ahead.
So if the landlord had, I guess, accepted the other tenant to take the guy's place, and then let's say, for example, they were there for all of what would have been his lease term, except for maybe like 2 or 3 months, would he still be on with I forgot his name, the first tenant? Would he still be on the hook for whatever of those months?
Right. So usually, let's say that the landlord exercised due diligence and the apartment was empty for 2 or 3 months, and they finally found a tenant after 3 months, right? The usual rule is that the original tenant, Kreidel, who signed the lease, would be on the hook for those 3 months of rent. That's the usual rule. But in this case, it's so weird because he never took any efforts and he turned tenants away. Kreidel's on the hook for nothing, 0, just the first and last month rent, the security deposit, which is, you would think that at a minimum he has to pay some rent, but the court says there was never an effort to release. Therefore, there's no duty to mitigate, and therefore there's 0 damages due. So the lawsuit owed 0. Okay. All right. I have just about a minute left. I'll start the minute poll. So if you're sensing a pattern or perhaps a summary of these cases, it's think back to contracts. Whatever doctrines you did in contracts will generally apply here. No self-help. All right, there's a breach, you go to the courts. Yes, duty to mitigate, right? If there's a breach, the landlord can't just sit there and hope to collect damages. You have a duty to mitigate. So whatever doctrines you learned in contracts very likely apply in the context of leases, not in freehold, not in life estates, fee simple, none of that stuff, but they will apply for for the leases. Oh, I'm sorry. Minute polls, multiple choice. That's not very useful. I'm sorry. A bunch of you were answering A, B, C, D. You're funny. Okay. Thank you, Ray. All right, try it now. Is it good now? All right. I have nothing left. Anything else in your minds? Too funny, multiple choice. All right. Thank you so much. I'll see you. Office hours say 2:45. Otherwise, I'll see you on Wednesday. Thank you.